in her favor or in her support from time to time. Disposed.
I'm deeply obliged.
Is successful this time. Is successful this time. We could not persuade the Honorable Chief Justice in a review.
How it went to the Chief Justice? Just
Yes.
Sen was there.
No,
decided
he
the
filed
matter.
a review from an order in which Chief was not a party.
That is a judgment presided over by Justice Bhaskar Bhattacharya also.
Right.
Supreme Court.
Next.
Matter relates to
appearing on the statement.
interest on gratuity.
Yes.
Interest on gratuity.
Interest on gratuity.
Which group is staff?
It will be revised gratuity.
Yes, Lord. Revised.
2019 revised gratuity.
Favoring us.
Yes.
27 minutes.
27. Right, item 27, my lord, I made an application for addition of party. I am representing all the
What is your CAN number?
CN1.
1 is there today, but 2 and 3 files.
There are what I suggest.
Files are not here because date is mentioned.
On this point, there seems to be a couple of matters. Now, I am representing for the untainted persons who in the last time they thought they are untainted, they don't have to think anything about their life. Now we have faced it. So once it is decided either way, my lord, we want to say our view because now it's they are seeking to challenge the, my lord, the statute itself, that prior teaching experience 10 marks. At what time it should be given? That's the law point.
No, not at what time. The entire thing is ultravirus.
Well, then fine, entire thing cannot be taken because Supreme Court has affirmed it. But in any case,
point has been decided. No, not at all.
all I say today that
Not at all.
in the earlier entire proceedings, because I thought I am an honest, I need not be a part of the proceedings. I lost my job. This time, my lord, I am so apprehensive. That's why I have made an application for addition of party. Either way, Lord.
All right. What is the application 2 and 3?
Lord, you may add a skip.
Yes. Addition of party. Untainted candidates addition. You also same thing. You are challenging the rule.
In my case, there is no classification of tainted, untainted.
All right. Please place your case.
Yes.
The opposition is there.
Yes, my lady, may I just add?
So many requisition is pending in same point,
Virtually.
and we also
May I
find
just add
requisition of
point
party.
here?
But I was suggesting,
Don't
yes,
tell.
but that's the reason I was suggesting.
One matter is there before the court.
Yes.
The council is present. Let us start.
My lady, I'm so sorry to interrupt. May I just place one point here, my lady? I appear also for the untainted.
Yes.
My lady, I also appear for the untainted. We are untainted candidates who've taken the exam successfully. But this issue, my lady, of this challenge of this rule has been previously decided by the Calcutta High Court by a division bench, my lady, upholding the rule and security requirement.
Very well.
Giving
Yes,
past experience. So, for
All right.
instance, if you have...
my lord,
Yes,
in the
let's take
meantime,
it into
the copies of the can may be given to us also. I'm not praying for an adjournment, but it may be given to us. We'll know that who are the applicants.
All right.
Receive one can for the commission.
One. Can
And we have received none. State has received none.
Well, according to, I'm sorry.
can one?
No, we have received all.
You've received all. The cans which have not been served upon the parties, please do serve.
Yes, but we may also get a copy so that we know
State can also
that what
be
points
served.
are being taken.
And the board is also there. Board can also be served. All right. Those who have not been served, please do. Yes.
The point arises, the background of this, let me tell you, there was a selection for appointment of teachers in 2016, which was set at not a whole hog by this Honorable High Court, which has been upheld by the Supreme Court. That's not the issue. Now, the Honorable Supreme Court, my lord, gave them liberty to go for fresh recruitment. Now, in the name of going for fresh recruitment, they have enacted new rules. That rule is under challenge, its virus is under challenge. The virus of these rules was never challenged anywhere before. The court has recorded in division bench, the rules are not being challenged, therefore you are not interfering. Now, kindly come to the my lord, the rule. That is at page 32.
Yes.
This is of 29th of May 2025.
Why are you challenging it here in November?
No, the petitions are pending before this court for some time.
There are petitions pending, but you have not challenged it.
Yes. No,
Your-
you mean
Filed on 31st October.
my lord, several persons have not filed this petition challenging the virus of the rule. This is one of such petitions.
In November.
Yes. Anyway, but in November doesn't matter. That the challenging of virus does not depend on the particular time. The kindly sees below what is these rules. These rules are below framed in by virtue of section 17 of the West Bengal School Service Commission Act 1997. I just take your lordship for prima facie satisfaction few of the provisions. The kindly comes to the provision of a selection of vacancy. This is very important.
Page
35, Rule 7.
All right. Information regarding vacancies.
Yes. The
Yes.
Commission of School Education shall, on being intimated by the West Bengal Board of Secondary Education, as and when deemed appropriate by the board, prepare a vacancy statement. Vacancy statement of assistant teachers. Therefore, the teachers who are already there, they really are not getting any vacancy for them. And with the approval of the state government, send the same to the board. The board shall, with approval of the state government, send the category wise so and so and so. This is the creation of vacancy for fresh selection. Now, while fresh selection is made, then the parties should be treated, my lord, at level, at par. All the applicants will have the same benefit of getting the getting entry into the service. Immediately, my lord will find that in these rules, they have created a class amongst the class. Kindly come to the schedule. This is the educational qualification, including professional qualifications for selection of assistant teachers. Therefore, the educational qualifications are at the entry point fixed. Now, kindly come to page 42, Schedule 2. Selection to the post of assistant teacher for class 9 and 10 shall be made on the basis of marks obtained in the written examination, educational qualification, prior teaching experience. If this is a fresh recruitment for the fresh vacancies, you are inviting the existing teachers to participate, along with the fresh recruits, fresh graduates, fresh entrants. Oral interview and lecture demonstration determined by the Central Commission. Written examination, OMR based 60 marks is common to all. Academics, educational qualification common to all. Then kindly come B, prior teaching experience, 10 marks. Therefore, this 10 marks is additional benefit to a particular group who are also equally applying for entry into the same process. Whether this can be done. This would be apparently and patently in violation of Article 14. And then oral interview and lecture demonstration. Now, lecture demonstration of the persons who are allegedly worked, though illegally, and the appointments were set aside by the Honorable Supreme Court declaring void. Another question would come whether they can be given the benefit of that so-called experience. This prior teaching experience 10 marks would violate the Article 14. You are creating a class among class. Now, this is the virus which I am challenging. Herein before, well, I must say, because I had the occasion to appear, petitions were moved by some group where the Honorable Division Bench says, since the rule is not under challenge, we are not interfering, giving certain reasons. Therefore, now the scope of this court, consider the widest of the challenge. Is that matter is still pending, and this is the petition that where I am challenging basically on this ground that you cannot at the entry point create a classification. By that you are trying to give advantage to the persons whose services were terminated. That's the intention. That you can come through back door. Giving 10 marks means all other new entrants will be out at the very threshold. Whether this can be done. This is the point.
Then, has the list of tainted and untainted candidates been published?
According to me, not. According to some, yes. The list which has been published, which I can demonstrate if your permits me from the Supreme Court judgment, is an incomplete list.
Right.
Again, to protect a particular group. But I am not on that. I say that if the rule goes, then whether tainted, untainted, everything should go. At the threshold, everybody should be put on the same level without giving any additional advantage to X, Y, Z. That should be the compliance of Article 14 and 16 of the Constitution.
Show me the direction of the Honorable Supreme Court regarding this.
Copy আছে? না না জজ সাহেবকে দিতে হবে।
সিঙ্গেল বেঞ্চে প্যারা 12 এই জন্য ডিভিশন বেঞ্চ আর বলেনি, সিঙ্গেল বেঞ্চে প্যারা 12 বলা আছে।
মিত্র স্যার
যেহেতু একটা করেছে রে ভাই, সবই তো একই ব্যাপার।
Give me the number. It can be put on the screen.
Yes.
The officer the number.
No.
Judgment delivered on
সুপ্রিম কোর্ট।
হ্যাঁ 3rd April। কেন হার্ড কপি আনো না? বলি কথা শুনি এনেছি কোথায়? কাজের সময় পাও না এনেছি। এটা রিপোর্ট রয়েছে তো এটা।
2025 INSC 43
বলো ওদের
2025 INSC 43 দাও 2025 INSC
43 তো করে বলি কাজের সময় ঠিক তৈরি থাকে না, খালি মুখে মুখে তৈরি থাকে।
আইপ্যাড থেকে দেখানো
এটা রিপোর্ট হয়েছে তো।
হ্যাঁ রিপোর্ট।
তাহলে সেটা দিচ্ছ না কেন?
2025 INSC 437
My lady, I wish to interrupt. May I just make one point while my friend finds the papers, my lady? That the Supreme Court actually ordered the publication of the tainted and untainted lists.
তর্ক করছো কেন?
And to publish the list of the
দিয়েছো ওখানে এসছে
Page 35, Rule 7, you mentioned something regarding the vacancy statement of assistant teachers, right? Your submission is that since the teachers are already in service, the post cannot be treated as vacant. But then the entire selection process stood nullified. Then where is the question of
that stood nullified?
Yes. Though the seats have to be treated as vacant only.
Yes, then how could you give additional 10 marks for teaching experience?
To that teacher.
This is a post for fresh recruitment, fresh graduates at the entry point. Then you come as a fresh graduate, but you cannot have the benefit of 10 marks for teaching experience. I am not considering whether this was void or not. That means you are creating class amongst.
That I've got.
That you cannot do. And at the entry point, whether there are Supreme Court authorities.
I have followed it.
দিয়েছো সাহেবকে? Well, in the meantime, may I read out?
Yes, please read out.
The conclusion of Supreme Court judgment, paragraph 45. The last question relates to the relief and whether it requires any modification. We find no valid ground or reason to interfere with the direction of the High Court that the services of the tainted candidates were appointed must be terminated, and they should be required to refund any salaries or payments received. Since their appointments were the result of fraud, this amounts to cheating. Therefore, we see no justification to alter this direction. The next paragraph. For candidates not specifically found to be tainted, who are claiming to be untainted, the entire selection process has been rightly declared null and void due to the egregious violations of illegalities which violated Article 14 and 16 of the Constitution. As such, the appointments of these candidates are cancelled.
31st October. 31st
However,
December
the candidates who are already employed need not be asked to refund or restitute any payments made to them. Their services will be terminated. Further, no candidate can be appointed once their entire examination process results have been declared void. Therefore, the Supreme Court is very categorical that all the appointments having declared void, none of them could be appointed. There is no doubt in it.
All right.
And this bias of the rules was never challenged before. The division bench of this court said recorded that since rules are not challenged, we are
Division bench's order, please.
This is division bench's order.
division.
The division bench's order I have handed over, my lord. Arunima Paul.
Provincial is ordered now.
Yes,
And
16 July 2025.
10th of July 2025.
so 16 July 2025.
In the matter of
Bench.
16 July.
Orunima Paul has been placed.
Arunima Paul?
16 July.
It must be the same thing possibly.
16 July.
Same thing. 16th of July. Yes.
No, my lord, just before he.
Let him finish.
No, my lord, the writ petition, in the writ petition from which this appeal arose, my lord, there was a specific prayer, my lord, towards by. And my lord, it was given up before the honorable single judge.
Whatever.
Let us-
Yes, you
let us
will
not-
get a chance.
Let us
Yes.
not go by the judgment of the court.
Yes.
Kindly come to page 24.
Yes.
Division bench.
From the-
We order to
Yes.
continue.
The recruitment rules 2025 has not been challenged by any of the appellants. In that background, the division bench order comes. But I know this specifically because I had the privilege of appearing before the division bench and
Yes.
Supreme Court as well. And then, this order was appealed from. Supreme Court did not interfere.
All right.
But the point of why this challenge remains wide open.
All right.
And that's now I'm being conversing before your lordship.
All right. This is all? Yes, Commission. It is your rule.
Commission.
Your rule that has been
State
challenged.
rule.
By rule,
The
Malad.
state rule. All right.
Yes, Malad.
Yes, state.
Malad, I'll start by submitting that Malad, the learned advocate general has not been served, but I understand the bench wants to Malad look into the matter, Malad. So I'll address your lordship, Malad.
Please do.
Malad, Malad, the petitioner essentially is challenging the granting of the marks for the prior teaching experience. That is the long and short of the submission.
Yes.
Now, Malad, first your lordship kindly will take, Malad, the other batch of writ petition which was taken, if I may point out a singular paragraph of this honorable single judge's order, which was thereafter travelled before the honorable division bench.
Court's order I have handed over.
Malad, the single bench I'm handing over. The same, Arunima Pal. Yes. Single bench for now?
Just give 2 minutes.
Now, Malad, Malad, we have the copy of Arunima Pal writ petition also, para 12. We have the copy of the writ petition also, which clearly says in the prayer that the various of the rules were under challenge.
But then the division bench is.
I'll say why this is coming. I'll say why this is coming. Can you take paragraph 12?
Yes.
learned senior advocate representing other groups of petitioners at the threshold has submitted that prayer B of the writ petition being WPA 13457 is not pressed, wherein declaration is sought for to the extent that the declaring the rules of 2025 and the recruitment notification dated 30th May 2025 ultra-virus. That prayer was given up. That is why the Honorable Single Judge did not decide the virus. And that is from where this submission is coming. Now kindly take the division bench's order. First, my lord, kindly take paragraph 28.
Yes.
In reply, Mr. Bikash Ranjan Bhattacharya, learned senior counsel, has submitted that the writ petitioners are not challenging the virus of the recruitment rules 2025, as their rights are untainted. Rights as untainted candidates are fully secured and has to be tested on the anvil of the judgment of the Honorable Division Bench in paragraph 363 Roman 11 read with paragraph 49 of the judgment of the Honorable Supreme Court. Now can I take the prayer of Arunima Pal? Give the prayer of Arunima Pal.
I'll give you.
But I am giving a soft coin, kindly pardon me, Malad. This is the prayer of Arunima Pal.
All right. What is
where
the prayer?
the virus was under check. I'll read, Malad. Prayer B said that in Arunima Pal, a writ of andor in the nature of declaration declaring that the Kolkata Gazette dated 29th May 2025 issued by the Office of the Principal Secretary of the Government of West Bengal and the notification dated 30th May 2025 issued by the Commission as being ultra-virus to the Constitution of India. Now, my lord, this I believe is also filed from the same chamber that I find from the advocate on record's name, my lord. So, my lord, they are well aware that the virus was under challenge and it was given up by the before the Honorable Single Judge. Though the submission, no, it's about being aware whether there are averments or not. Now, my lord, kindly takes the constitutionality, whether the state was empowered to introduce 10 marks prior teaching experience or not. Now, my lord, kindly takes paragraph 34 of the judgment. Division bench, page 22.
Yes.
The awarding of 10 marks is an weightage to be given. Weightage to be given on the basis of the experience, and it is only expected that in a selection process of this nature and kind, all the candidates are required to undergo the rigors of the selection process. In order to select the most suitable candidates, proportionate weightage based on the length of experience to the extent of 10 marks be given to such candidates is not arbitrary. The object is to select and appoint experienced teacher, as rightly pointed out by the learned Advocate General and the learned Senior Counsel, appearing on behalf of the Commission. The appellants writ petitioners are not coming within the purview of the category in whose favor the benefits and concessions has been extended in paragraph 49 of the judgment of the Honorable Supreme Court. They are not candidates selected in the 2016 recruitment process. In the meantime, they have not also applied for the service in any educational institute. General kindly skips over a few lines to the next page from the third line. If we accept the submission of Bikash Ranjan Bhattacharya, learned senior advocate, then for the selection for the same subject, teachers, two different eligibility criteria has to be applied. The eligibility criteria in the selection process of 2016 is different from the recruitment process of 2025. The rules are more stringent and student-centric. The revision of the eligibility criteria, so and so, then the NCT, that NCT also allows it, is discussed. Then Malad kindly takes towards the bottom of that page, second last line. While the candidates with 45% marks in graduation may be eligible for the same subject a candidate requires to apply under the recruitment rules of 2025, would have to fulfill a criteria of 50%, and both of them, if appointed, may be a teacher for the same subject teaching in different education institutes. This will result in discrimination and a compromise of the quality. The prior teaching experience is an important factor, as experienced teachers may impart education for effectively and efficiently. The recruitment rules 2025 has not been challenged by any of the appellant. The delay, but this is where, that is why the single judge's paragraph was important. They prayed for it but gave it up. The delay in the recruitment, fresh recruitment, is due to the pending litigations, and when the opportunity for employment is opened by advertisement, it is always open for the authority to decide the eligibility of the other criteria in the academic interest for the benefit of the student. We accept the submission on behalf of the state respondent that there is no specific direction in the order of the Honorable Supreme Court by which the state is obligated only to fill up the declared vacancies of the first SLST 2016. All the orders relating to the issue had directed the fresh recruitment to be carried so and so. Then Malad kindly skips over to the next paragraph. If the government, 35, if the government felt that the experience gained by the candidates is relevant, the court cannot take a different view in judicial review. Similarly, prescribing any age limit for the given post and also deciding to the extent to which any relaxation can be given to the said age limit are essentially so and so. But these are on the other points which has been discussed. Then I am skipping over a few lines. Any process which applied equally to all the candidates and was designed to garner the best talent cannot be called arbitrary or irrational. The eligibility criterion in the recruitment rules 2025 is in furtherance to the object of finding the best available talent. The prior teaching experience has been considered by the division bench. It has been held that we are empowered to introduce it, and it is held that the court should not interfere in judicial review when the administration has thought it to be a fit exercise of their discretion, administrative policy. This point, I need not elaborate whether the prayer was there or not, whether it was given up or not. It was prayed, it was given up. As far as the state is concerned, it is issue estoppel. This point has been decided. This order has traveled before the Supreme Court. We are placed in several matters, and all the points are discussed here together because there are many other challenges by several petitioners. All my learned seniors assisted the Honorable Supreme Court. Your Lordship, even assuming that there was no challenge, it's a fresh challenge, fresh batch. Who is ultimately what is the point? The point is, first of all, whether I had the power or not. Secondly, whether it's ultra-vires the constitutional scheme, whether it's creating arbitrariness is or not. But the power has been upheld by the division bench, then the Supreme Court, and the fact that it is not arbitrary within the campus of Article 14, that has also been discussed. But Supreme Court, I can copy
Supreme.
I won't take soft copies.
No, Milord.
Yes.
Therefore, this point, your Lordship will kindly not go into any further.
Yes.
Your Lordship will not hear.
May I?
I will. Certainly, I will hear.
I will point the government.
Yes.
My lords, may I assist my lady, my lords, by just making 2 or 3 points, my lords, if I may.
Just wait, madam.
Yes, very well.
Paragraph 6, page 4 of this judgment, which may have been placed, could have been placed. Paragraph 6. My learned friend Mr. Vikas Ranjan Bhattacharya appeared and what he argued. Mr. Bhattacharya submitted the finding, observations, directions about order to be strictly followed. That's all right. Mr. Bhattacharya further submitted notification, etc. Then may come. Further submitted that there has been significant change in the rules which would render the present applicant disqualified. It is submitted the prior teaching experience for 10 years was not an eligibility criteria in the earlier notification. Moreover, the percentage mark has been given arbitrarily and otherwise qualified. So these are specifically argued. Please, see by Mr. Bhattacharya further argument. Please come to me at paragraph 24 of this judgment. Page 15. Mr. Bandopadhyay, with the argument of the government, a commission was justified in awarding, has justified the awarding of 10 marks for prior teaching experience on the ground that it also extended to the teachers who have taught in schools under Kendriya Vidyalaya Sanghan, etc. and training and other government-sponsored schools. Marks for prior teaching have been provided with a view to appointing experienced teachers who will be able to teach. Pausing here, Milord. Now, what you argued here, because this teaching experience marks, 10 marks, are being given only to those unsuccessful candidates who failed. It is not so. The teaching experience 10 marks are available to everybody. even his client applicant,
সেপ্টেম্বরের
if
অর্ডারটা
he has
এটা
got
পরে
teaching
রিপ্লাই করে
experience
দেবে
in other schools, etc.,
সেপ্টেম্বরের
he get
অর্ডারটা এটাকে
admitted.
কন্টিনিউ করতে
He
বলেছে
got a class within class.
আমার পোস্টটা যে
See,
ভ্যাকেন্ট
without the point, see, the teaching will be given to all who have, not necessarily to those who have appeared in earlier first stage and failed. No.
পয়েন্টটা এমনি কোনো জোর নেই
But this is it
যাদের
wrong.
পয়েন্টটা আগে
It
করছে
is not confined to the candidates who had succeeded in earlier first and thereafter been disqualified because of others' fault. It will be available to all. It is made clear.
But why will the freshers lose this 10 marks? Why will the freshers lose this 10 marks?
The freshers, if they are teaching experience as applicants of other schools, they will also get.
No. Freshers. Fresh candidates not having experience. Why will they lose this opportunity?
There were fresh candidates. If they have teaching experience, they can get.
Those who have got teaching experience are not fresh ones.
Experience, why should they include it? That's issue. Is the teaching experience, what is being argued by Paragraph 24? The teaching experience have been taught in school under Kendra, Vidya, etc. Marks for prior teaching have been provided with appointing experienced teachers. That were experienced teachers, they will get the eligible points. What's wrong there?
Why will the fresh candidates not be, or rather lose this 10 marks?
No,
This has been answered.
Because teaching experience is a valuable qualification.
Yes.
Not all the applicants who can avail of this, provided he has no teaching experience. Now, is it argued that this qualification mark of 10, given for teaching experience, is bad? Or why is it bad? Why is that? Can you see paragraph 35?
34. 34 also, sir. 34 has answered the point.
35. And what the court said.
34 court line to answer.
If the government failed, can you see me not paragraph? If the government failed, that the experience gained by the candidates is relevant. The court cannot take a different view in judicial review.
আরে বুঝেছি কিন্তু তোদের এটা ধরে চললে তো হবে না সবকটা কনসিডার বিপদ হয়ে যাবে
That is all done by expert body. That is also mentioned in the document that these criteria have been fixed by expert body. And why the second interfere with them? Now, my lord asked a question, but I'm happy in my lord. So why 10 months are these will be given for experienced teacher? Answer is that government values experience. And those candidates who have got teaching experience, they should be awarded by diplomas. Because you get a teaching experience. That is what was argued. And not can you not come to the paragraph? This is if it has been taken the point, can the court cannot take a different view? If the court, if the employer thinks that the teaching experience is a valuable asset, for which can be delivered. It is why it is arbitrary. It is open to all. It is not that has there been teaching experience of only the first level failed should have been given. No. It's just not. Anybody can speak. Blood people who have got no teaching experience they have done. People who have got teaching experience they are also going to do that. Some people have now these people with full knowledge of this qualification and taken mark have applied for and participated in examination already. They have appeared, participated in the examination held in September, appeared there, and with full knowledge. Now, after having appeared, they say that you can just candidate that. List of dates রয়েছে স্যার list of date তোমরা on the petition I go without copy my lords I'll show you a document of Supreme Court. They have appeared, participated, everything, with knowledge of this. At the time of appearance or the application, they have not taken any objection to this rule, knowing that they don't have anything in details. Like whether I meet it. Because the judgments, the largest and cited of Supreme Court, that was modified by judgment Supreme Court as that has not explained. The judgment 17th April. Can you see that 17th April? Order. Or Supreme Court. Then I will give you a list of this.
Order.
Supreme Court changed the view.
My lord will kind.
He may not. In this case, Supreme Court accepted the prayer. The judgment cited by Mr. Subjective was earlier done.
Yes.
Client accept the prayer made in the present application. In further, it relates to accept the details or process and not how you take. Subject to the following condition. First of all, it is all triggered by Supreme Court and Supreme Court figure timetable also. And at the same time, for the fresh equipment that was set forth shall be published before 31st May 2025. Second is very important. Examination and the entire equipment process shall be completed by 31st December 2020. It's an historical. State government, applicant, appellant, West Bengal, etc. shall file affidavit by 31st May 2025. Enclosing therewith a copy of the advertisement for the press recruitment as well as schedule therefore, so as to ensure compliance of the complete recruitment process. In case advertisement is not submitted, consequences follow. Which likewise order tell them is that conferring and special right to anybody. That's the point. You don't confer special right to anybody. The deputy will be special right or special right. That's what it is. As in conferring a right to an untainted candidate to appear and only a doesn't confer any special right upon them. The same right the best candidate also has. What is the right they don't have? The question of right to apply is different from the qualification marks of it. Criteria for that. They are the same right to apply as the order says that only untended candidates will appear and nobody else. Then Mr. Bhattacharya could have fixed. No special right will give to anybody. No matter as fresh recruitment process is concerned, no matter anybody can apply. This application is not confined to untended. It's confined to fresh candidates also. But what the order of Supreme Court, what does it get? The fresh candidates will get some advantage. That even though they have no teaching experience, they will get 10 marks. What is this argument now? After being done, kindly this is timetable, everything scheduled by Supreme Court. Triggered by Supreme Court. Now, without after appearing, that is take back this topic. So, give me some. আমার কাছে আছে আপনি করুন স্যার আমরা দিয়ে দিচ্ছি Can you take a list of the similar all these relevant facts which should be rejected outright? কোথায় গেল আপনারটা কোথায় গেল দেখুন 29th May, 17th April order was passed to publish the advertisement by 31st May. 29th May application within time. Publish the rules. That is publish the rules called the website etc. for appointment to the post or as assistant teacher applicant etc. and physical. This is that can be equal page. Each number is given there. Next, 30th of May 2025, notice issued inviting application for conducting second for the classes 11, 12 also. In the pursuant to the judgment dated 3rd April passed by the Honorable Supreme Court, stating that the said selection process shall be governed inter alia by the rules 2025, relevant acts and subsequent amendments. Noted that the amendment process started on 30th of May. Can you see the notice where it specifically mentioned that Rule 225 will apply? They have seen that notice, and pursuant to that, they have applied. That please see the notice which is annexed. There is it is shown. I'll show it to you, Lordship. Let me finish the list of this and show it to you, Lordship. Then 16 June, online application for appearance in written annual day and meeting signed up. Otherwise, then 14 July, last date of receiving the online application as per schedule, etc. Then 7 July, Rule 25 governing second action was challenged on the ground that 10 marks for teaching experience should not be granted, and the same was dismissed by the almost single bench on 7 July. That order of not seen. Mr. Bikaran Bhattacharya argued, he knows better. He's argued noted, he was arguing that giving 10 marks for teaching experience is bad. Same arbitrary void, etc. That I must again point out, because single bench dismissed the petition. Men are on the ground. Another ground was the untainted candidates. Tainted candidates should also be allowed to appear in the second examination. But Supreme Court said only the untainted appear. So because no, they said right, only that prohibition of tainted candidates should remain valid, and not on that ground it was dismissed. Single bench has not specifically given reason why this 10% except his influence is good or bad. Right. From that, they come to the division bench appeal, which has been placed before Lordship. 16 July, writ petitioner being aggrieved by the judgment filed an appeal before division bench, which was also dismissed after hearing the parties, until observing that awarding of 10 marks on the basis of experience is not arbitrary. That paragraph was shown, I can prove it. Then, Milord, special SLP was filed. We have got a copy, keep the copy ready. SLP was filed. Same was dismissed by the Honorable Supreme Court, not by with reasons. With reasons. After observing, we find no good ground and reason to interfere with the impugned judgment of the High Court. Can you see the judgment? A Supreme Court a dismissed college. SLP dismissed. We got a copy, I'm handing what a copy to your Lordship. You ready, good? And with this, we're quoting from that judgment. This is the handing up. Mr. Bhattacharya appeared. He knows this better than me.
Therefore, I know better.
I know better than me.
Unfortunately,
That this had happened. You know that this had happened.
I know what is happening and what is going to happen.
Not what
Anyway.
is going to happen.
He knows what is going to happen.
With reasons they have been dictated. Then my list of this serial number 7 only come to. Lead petitioner Bhim Kumar Sarkar received his admit card issued by the commission for examination to be held on 14/9. Can you see page 31 of the lead petition? The document is annexed in the lead petition. Page 31. No, I'll show later. Page 31 lead petition. Lead petition page 31 দেখো আমারটা কোথায় গেল আমার বিপ থেকে হারিয়ে গেল It is mentioned below for particular examination date is mentioned. Admit card is for that date. And that was for class assistant teacher 11 and 12. That also mentioned.
Yes, then I have seen.
Then he appeared in examination 14/9 with full knowledge. And you can no. Then the next date. 22nd August. Notice, Miller, can omit D. Notice was issued by the commission permitting the selected and appointed untainted But not typing mistake, can only make it untainted, not untainted. The spelling mistake. Candidates, another 10 days, time was being extended for submitting application. Extended. After Supreme Court or then mirror 9, serial number 9. 7/9/25 written examination by the assistant teachers held of 9 and 10 held. And on 14th September, this is important, a file for the assistant teachers for 11 and 12 was held. And this in this petition appeared. Here and got the admit card for that. A petition ready. Now, read petition, then 14th September, petitioner Bhim Kumar had taken the written examination on the said date and result was awaited. Now, on 31st October, pending that, he made this writ application. And what is first prayer? He the prayer 10%. In the same present petition, have filed petition challenging Rule 25 on the ground that teaching experience of 10 marks cannot be awarded to the selected untendered candidates. He the prayer A, or the writ petition. That is the ground he has taken. Prayer A. On that ground, cancelled. And this has been division bench judgment shared in the face, which has been approved by Supreme Court by giving reasons. And in spite of that, 2 points arises, Milo. Can this petition be allowed to be moved when time officially there is no case and this order is of division bench judgment is binding on everyone, which is approved by Supreme Court. Therefore, no case, time officially case is made up. Therefore, take it into account that single bench may be pleased to say, what can I do? I have good deal of sympathy, but I am bound by judgment of division bench approved by Supreme Court. Second point, the time schedule and this selection process for untended candidates, etc., has been triggered and fixed by Supreme Court order. Supreme Court has fixed a date. The 31st May is the date by which you must issue the notice inviting application. And further, that process must be completed by 31st September. In the middle of that, on 30th October coming, can this selection process after having started, can that be interfered with at this stage? And the time is fixed by Supreme Court. It will delay the selection process.
Yes.
So, this is the now it's in matter which is in the domain of Supreme Court. They are now getting interfered by the Honorable High Court. Just to in my humble submission, in by stricture of Supreme Court. It will not, if order is passed, any interim order is made, then that will affect the progress. Secondly, thirdly, I point out, it's about minor discussion, well settled principle. When the recruitment process has started, and on the basis of rules which are known to the appearing petitioner, and on the basis of which he has applied, without mentioning that I'm making the application without prejudice to my right to challenge, etc. Can he, after examination, when results are to be published immediately, very soon, the commission can take it off. Can it be at all be allowed, should be entertained by the court at all? This is my first submission. In the court, in its discretion, should be particularly in view of the fact that the matter is fixed by Supreme Court. And they should apply to Supreme Court then, that kindly similar the notice of recruitment by paragraph. Notice of recruitment. Notice of recruitment, that notice here, I taken out. No. Lordship in the notice is clearly mentioned, which are quoted in a list of dates, that it is Rule 2025 will apply. Please similar the what?
Yes. Rule 25 will apply. 25.
Now, what has been apart from on merits also, no ground has been disclosed. Why this additional teaching experience mark, a particular mark, 10 or 5, whatever maybe, for a particular kind of experience, teaching experience, which is a valuable asset of the candidate, cannot be given. Fixed by expert body. And division bench said that if they have fixed it, look, nobody has, can you see, no, they have not argued. The teaching experience is irrelevant matter for the appointment of teachers. If the argument could not be made and has not been made, the teaching experience is an irrelevant consideration for appointment of teachers. I humbly submit, nobody can argue that teaching experience is irrelevant consideration for teaching. For teachers. For teachers. It's not appointing football players. There I could say the teaching experience 10 marks will be given to a football player for being appointed in the team. It is being given to teachers. And teaching experience is valuable qualification. That experience. So without this petition will be nipped in the bud. It should not be without entertain at all.
Did I hear you?
Yes.
You?
Yes.
All right.
There are couple of points which have been taken and that was identical, so I won't be touching the same. All points by Mr. Mitro, my lord. In fact, I also had in my mind, I'm not touch it. First, I would address on a very fundamental point of view. Mr. Bhattacharya, in my understanding, is trying to portray a picture of the world where either there black exists or the white exists. In other words, I said metaphorically this part. In other words, the word void, null and void in the Supreme Court's order, it's so clear, so watertight that it cannot be tweaked. Either Supreme Court having declared null and void, does it mean that Supreme Court has also said whatever is also attached with all the candidates minus the tainted? Because well, I'm not appearing for the tainted, so tainted it's done. Kindly look at from this point of view. I do not say that in a particular situations the court cannot declare something to be void, null and void, and the consequence of the same means absolute zero, no experience out of it. It can be. But contrast it with the situations, having said null and void, the same Honorable Supreme Court also said and felt for us, in a sense, saying that who are working somewhere else, they will also be able to resume their duty, number one. In other case, Lordship, kindly take paragraph number 47. Lordship will see the meat path being taken by the Honorable Supreme Court. It's not black or white. Yes, selection process has been found to be illegal, right? Does it necessarily mean that all the fair candidates who have put in labor, who have received money, and who have also, my lord, whatever experience they had, who have done the teaching experiences, does it automatically go from their experience? To that effect, there is a clear answer by the Honorable Supreme Court in paragraph 47. Well, the copy is there, possibly with your lordships. Kindly take 47.
Supreme Court judgment is not here.
It is.
Yes.
That's the main judgment. Mr. Bhattacharya has read out 45. So I am not reading 45. Now kindly see 47. That is the tweak and that's the middle path. And recognition of, I may not use the word sympathy, but that what we suffered is a collateral damage. We are honest. Now that was acknowledged.
And the list I would like to see.
Yes.
The tainted and untainted or something. How is that been
that they would
you do not know, commission will get.
So far as we are never been in the list of that. That's for sure. 47, kindly see, some of the appointed, Lordship has taken 47. Yes. Some of the appointed candidates who do not fall within the category of tainted candidates. So this is the first tweak. May have previously worked in different departments of the state government or with autonomous bodies, etc. In such cases, although their appointments are cancelled, these candidates will have the right to apply to their previous departments or autonomous bodies kindly mark the word, to continue. Well, there is a difference between the words to begin fresh and to continue. And to continue is the recognitions. Yes, we have to no other alternative, but we also recognize that you had a service, and thereafter kindly see, to continue service with those entities. These applications must be processed by the respective government departments or bodies within 3 months, and the candidates will be allowed to resume their positions. So just like us. Now kindly come to the other point, leaving aside Supreme Court judgment. If I put a question to myself, can prior teaching experience be a criteria? Well, kindly take any professions anywhere, even in our profession also. Experience is an age versus someone who has got the educational qualification. If the authorities feel that, and there are variety of rules and also recognized by the Supreme Court in some judgments also, that having a paper degree is one thing, which is a prerequisite. At the same time, if someone also has in reality an experience of teaching students, giving marks for that, to my understanding, well, this is absolutely valid and legal. Yes, there could have been a complete block had the Supreme Court, have the Honorable Supreme Court, while referring to judgment, this is a meat path. Just because the word void, that void is in respect of the selection process, not void in respect of the money we have received, not void in respect of the experience we have had. Now that has happened, that is, in my words, it's a middle path. After recognition that we have suffered without being tainted persons. Kindly see, Mala, thereafter the most important word. Further, the period between the termination of their previous employment and their rejoining will not be considered a break in service. So recognition. So if Lordship kindly take one extreme view, that void means zero. So there cannot be a continuation of that. Thereafter, their seniority and other entitlements will be preserved, and they will be eligible for increments. So therefore, if I am honest, if I happen to be in a society where unfortunately there was a selector who was corrupt enough and I suffered, so the Honorable Supreme Court recognized my suffering as an honest person and therefore tried to preserve the experiences that I have put in. In other words, if I put one sentence, in other words, the judgment of the Honorable Supreme Court does not say that because we have declared it to be void, that means everything zero. That means all the teaching experiences that we have done, that comes to zero. That is not. Then this continuation seniority would not have come. Now, second point comes, this issue, well, the matter is pending before the Honorable Supreme Court. What I find is that in Orunima SLP, I have the soft copy, page number L, I am reading out the exact portion. Soft copy of the SLP.
Orunima Paul?
No,
yes.
The SLP copy.
Not the order. I'm referring to the soft copy of the SLP, my lord. I will hand it over. Page number, yes, page number, yes, page number L. Well, this is one sentence. I just read it out. Further, there was an extra 10 marks for teaching experience in the new rules, which automatically affected the candidates like the petitioners who could not teach due to the fraud played by the State Commission Board. So, my respectful submission before your Lordship is this. As an honest candidate, I have already suffered. We have already suffered because we live in a society where there is a corruption. Even if we are not corrupt, we lose our job after so many years. After that, now Lordship would be not taking the matter just a matter of technicality. Yeah. Also, Lordship would deliver justice. Justice to all. As a candidate who have been found to be not tainted, who have served from, my lord, this 2016 recruitment process, and for the system who have lost, And they have lost because of the judgment where seniority has been preserved, money have been preserved. Now state has framed and come up with a rule that this experience, I'm not saying this, any experience, because it's not just us, anybody who has the prior teaching experience, they will get an X marks. Is it really so ultra virus to Article 14? And my respectful submission before your lordship would be, it is not. Kindly have a look at this judgment of the Honorable Supreme Court. This is 2017 11 SCC 421. There, first lordship, kindly take paragraph 16, paragraph 16, paragraph 17, and then paragraph 21. This is, here the word is the weightage for experience. And kindly see on 21, irrespective of the whether weightage was from illegality or legality.
All right, 16, please.
Yes. Kindly see 16 circumstances, the members of the appellant union are entitled to know the result of the such and such. All that the learned single judge directed was to conclude the process and declare the result after giving such weightage to the past service of the members of the appellant union as the first respondent deemed fit and proper, which the Supreme Court also granted in paragraph 47. Now 17. We do not see any error in the directions given by the learned single judge, and we are of the opinion that the division bench is clearly in error in interfering with the said direction. Now kindly come to 21. The first respondent who was a party to the settlement recorded by High Court in its order dated such and such could not be permitted to raise the question of the enforceability of the settlement. More particularly, when all that the appellant seeks is only weightage for the past service of his members, which the first respondent agreed, in principle, I am on principle, to give to similarly situated persons working with other departments. The member of the appellant union have been working with the first respondent for long periods, period varying from person to person. Whether such employment was regular or irregular in law, in a different matter, the fact remains that their service were used by the first respondent. All my respectful submission before your lordship is this: once the Honorable Supreme Court in the main judgment recognized the past service for the honest candidates, framing of a rule by the state, not for honest, for everyone, recognizing the past experience as the teaching is absolutely not violative of Article 14 of the Constitution of India. My lord, I would just conclude by saying, because the points of Arunima, that this point, in fact, my lord, lordship may also think that this is a unique situation, because this is a kind of matter, unlike other matters, once the matter is over, my lord, Supreme Court usually puts a full stop. Now, this matter, the Honorable Supreme Court wants to see that entire selection process is completed by a particular date. So, therefore, and my instruction is, this point was not instruction, also there in the Arunima SLP. This point was taken, which was, my lord, ultimately not found to be accepted by the Honorable Supreme Court. And that is the reason they have come lately questioning, my lord, the virus of this prior teaching experience. So, I would conclude by submitting that, firstly, this is intra-virus. Secondly, the word void should not be looked into from an extreme interpretations, because in the light of paragraph 47, past service for the honest is a recognition. And thirdly, this point was taken before our bench, division bench, and ultimately have shown the SLP also, and not found favorable. So therefore, my lord, lordships may not pass a favorable order for the writ petition. These are my respectful submission.
So far I am concerned, my lord, can number 2, I am accepting the submissions of Mr. Mittal. Only thing is also I have given the copy of the SLP. Can you see the point of law number 12 and ground number 12? It has assailed the very awarding of prior teaching experience item. And the Supreme Court said no ground for it. No good grounds for it. So therefore they cannot agitate. And more particularly, paragraph 7 will also take note of this and sequence of instructions. The paragraph 7, they say the online application we made, we participated, then we approached the authority for taking corrective action. So they had everything within their mouth. In the month of October. And in respect of the recruitment notification, paragraph 7 of the report. These are my answers.
Commission.
I mean, for the commission, I
would like to see the list, tainted and untainted, how you have given the preamble of that list. What is the note?
Keep it at 3 p.m. Will come with the list.
It is not necessarily you have to come today itself, because I do not want to hear the reply of the petitioner today. I will go through all these things. I will require the list. And the petitioner will reply on the next day. The queries that is passing through my mind, I'll put forth so that everybody can come.
In order to assist the court,
yes.
First thing. The first judgment was delivered by the Honorable Supreme Court from the appeals carried from the division bench's order.
That is here.
The thicker judgment, paragraphs 49, 15, we looked into. After that, the West Bengal Board of Secondary Education, citing, dearth of teachers.
Paragraphs 49 and 50. Yes.
Now, citing, the situation likely to be faced by the students, had moved an application, and ultimately, as my learned senior friend, my Mr. Anindya Mitra, pointed out, the Supreme Court regulated the entire process, saying that this has to be done by this time, that has to be done by that time, everything has to be completed by 31st. Now, today your Lordship is looking into a petition which was, admittedly filed on 1st of November, 31st October, 1st of November. It was taken on record. Now, this writ petition, apart from anything else, suffers from gross and unexplained delay. And it is at the instance of persons, who, knowing fully well the terms of recruitment, participates in the process, knowing fully well that these are the particulars that they are likely to be fulfilled and they are not likely to be fulfilled. Had they been so vigilant over their rights, then perhaps in Orunima, when Orunima is one set of untainted candidates. Today, I don't find any averment. I take it. I don't find any averment in the writ petition as to who the writ petitioners are, apart from saying that they are eligible to participate. I take it they are also equally untainted candidates, but who were not recruited previously. Similar was Orunima. The fact remains, in Orunima, whatever the stand was taken, same prayer was sought to be foregone. A bunch of writ petitions was taken up. A point may be taken, that Orunima did not say that I am not pressing the prayer, but some other writ petitioner did. The prayer for declaration of the rules to be ultra vires was not pressed. It is deemed. Thereafter, the matter travelled to the Honourable Division Bench. Mr. Bandopadhyay, appearing for the state, has invited my lord to paragraph 28. My learned senior friend, Mr. Mitra, invited your lordship's attention to paragraphs 3, 4, the submissions. Apart from that, once again, please have a look. I need not read it, paragraph 35, what the Honourable Division Bench felt that in judicial review, whether that, can be 34, of course, and 35 thereafter. What can be done, what is permissible limits of judicial review. Now, today, looking at the entirety of the matter, this order of the Honourable Division Bench, at the instance of Orunima Pal, traveled to the Honorable Supreme Court. My learned senior friend invited your lordships to the grounds. This Honorable Supreme Court was definitely aware about the grounds, and ultimately, my lord, the Honorable Supreme Court, by rejecting the SLP at the threshold, there is no merger. But what happens is, my lord, the division bench's verdict remains. Now, my lord, a collateral challenge after July, August, September, no challenge, nothing. The examination is permitted to take place. The examination is held. My lord, they are stopped, if I may say so, my lord, with greatest of respect, from challenging after participating in the entire process, knowing fully well about, my lord, what are the possible consequences. Just to, my lord, negate today, the publication is in the offing. In today's morning matter, your lordship wanted us to take instructions. Kindly visualize, my lord, the attempted recourse to a proceeding under Article 226 also has to, my lord, satisfy the fundamental test of delayed recourse to a proceeding under Article 226. Someone who is indolent or an acquiescent litigant, who acquiesces with the entire thing, who accepts Orunima, and he doesn't carry or she doesn't carry anything beyond the dismissal of the SLP by way of a review. Whether it is entertainable, maintainable is another thing. But the fact remains, now another round of challenge, just to prevent the selection process which has been, my lord, earmarked by the Honorable Supreme Court to reach its logical conclusion. A writ petition is today filed just to prevent the commission from doing whatever is supposed to be done.
Very well. The list,
Yes.
please bring.
My lord, I will. My lord, just see, if your lordship.
I don't want the names. The manner in which it has been published is required. Names, the court is not concerned.
Lord, we have it. Just give me 2 minutes. Okay.
All right, you make a printout and give. That is all right.
Your lordship,
I
keeping
did-
it tomorrow.
Not tomorrow, next week.
Another matter is fixed, my lord.
10?
Lord, we,
Another 2 or 3 matters.
All right, then Monday I can keep it. The earlier ones which were filed, please give the numbers also so that they can come.
my lord, your lordship will keep it on 12th. Mr. Bandopadhyay is leading me. Lord, if he can assist your lordship's court in the event he's. My lord, other matters have been kept on 12th.
Some has
Some are
been,
10th.
some it has been mentioned kept on 10th, but then I don't mind keeping it on 12th also.
Let it be hard out.
Yes, 12th.
All the matters, my lord.
None is without on the issue. With the best of respect.
Then, my lord, my point of demur also need not be kept open. Since your lordship keeping on 12, let them also serve the learned advocate general in the meantime. Because
All right, all
I
right.
made the submission with my demur.
All right, all right. You will give me the,
Kindly
Manner-
indicate in my lord's order.
I'll mention it,
Yes.
the manner in which
Other
it has been
question.
published. Right?
Manner in
Names,
Very,
preamble.
very,
That
very,
is
very.
important. The names are not concerned. I'm not concerned with the names. I have followed your submission, but then the court, for the purpose of taking into consideration the Orunima Paul's judgment, all these things.
Kindly visualize. Orunima Paul threw a challenge to various issues, including marks. This writ petition is only restricted to marks. I could have understood that this writ petitioner Bhim approached the court along with Orunima and could have segregated his writ petition so as to invite a decision from the court specifically on this issue. Today, by filing a writ petition in the month of November and suggesting
So that is the reason I wanted the earlier writ petitions also to come on board.
earlier writ petition is all
No, they say some are pending.
No. We are on this issue, no. No, on this issue.
Age of those other petitions are also put the same. They may be 1 or 2 days older to each other.
There are some.
They are nothing from me.
All right, let us see.
I'm asked to the cacophony.
No, yes, let us see.
List is there. Document
Yes.
will speak. And let us argue on the question of law, not being swayed by tainted content.
Yes.
The question of law has
1 minute.
been suggested.
1 minute.
Formal order for the addition.
I will. Mr. Bhattacharya, I would like a reply on the issue of Arunima Pal, the estoppel issue. Something else.
They're different petitions.
Yes, I get that. And something else is also playing in my mind. The principle of obiter dicta will also be required. You please bring certain judgments on this.
Question of constitutionality of has no application.
Very well. Please be prepared with this and the judgments and everything. Please.
My lady, just one point, if I may make.
Yes, madam.
Yes, if I may make one point.
And who are you appearing for?
Logistically. My lords, my lady, I appear for successful candidates, untainted, and we are before my lady. We have taken the exam successfully. We are only here to say two things.
Is there any application on your behalf?
Yes, it's CAN 4, my lady. It's been filed as an implement application, CAN 4. CAN 4. But may I just make 2 points, my lady? One, my lady, in Sanjay Doloy, where 2 judges of my lady's court, the Calcutta High Court, actually heard this question and said that the policy, this is a policy decision, prior work experience being considered and being awarded 10 marks. Because you get more senior teachers, you get more experienced teachers, and that the judiciary should not travail into what is clearly legislative policy. One. Second point, my lords, is Sanjay Doloy's judgment was confirmed by the Supreme Court in July of this year. So that has attained finality. The third point is this, my lords, that this prior experience criterion, 10 marks, prior experience being given, is actually quite the norm. The UGC regulations on minimum qualifications for appointment of teachers 2018 also has prior experience as a criterion for recruitment. Very similar to what is before my lady. So this prior experience category cuts across the board when it comes to teaching and has been upheld in multiple high courts, including my lady's high court. So these are just the 2-3 points. And of course, my lady, I'll appreciate the opportunity of assisting on the next date.
All right.
I'm so grateful, my lady. I'm very grateful.
CAN 4 has not been served. Kindly request.
Yes, my instructing counsel will serve CAN 4. Please serve CAN 4.
It's not there in the list also.
It is not there in the list. Oh, very good.
It's only CAN 1 which is here, 2 and 3 is also not here, and 4 is not listed.
My lady, I believe it's been filed today.
Please serve CAN 4 to all the parties.
Yes. Please serve CAN 4.
We don't get the cost title when we go to different forums.
2 or 3 হয়েছে তো 2 আর 3 আসেনি 4 চলে এলো আচ্ছা
I'm grateful that my lady heard me. I'm grateful. Please serve CAN 4. Yes.
জীবনের প্রথম রিটে আমি তোমাকে হারিয়েছিলাম প্রথম রিটে হেরেই আছি আমি তো জিতি এটার পরে আমি কনফিডেন্স হয়ে গেছিলাম
not the certain provision of the
I'm taking lots of
recruitment, but then you are supposed to stay, isn't it, in that other matter?
I'll come from the morning.
No.
Recruitment notification dated 29th May 2025, published by the School Education Department, is impugned in the instant writ petition. Stop. More particularly, the weightage of marks provided for prior teaching experience is challenged. According to the petitioners, the same is contrary to Article 14 of the Constitution of India. Stop. The notification seeks to create a class amongst a class, which is impermissible. Stop. Paragraph. 3 connected applications have been filed seeking intervention. Stop. The applicants and the respondents in the writ petition oppose the submission and the prayers of the petitioners. Stop. The matter has been heard to some extent. Stop. The petitioners shall reply on the adjourned date. Stop. Next paragraph. Let a copy of all pleadings be served to all the parties. Stop. As there is a challenge to the vires of the rules, comma, let copy of all documents be served to the learned advocate general. Stop. The matter is made returnable on 12th November. Stop. Learned advocate representing the commission is directed to produce the preamble of the list published by the commission relating to the tainted and non-tainted candidates. Stop. Couldn't published by the commission in compliance of the direction passed by the Honorable Supreme Court.
Submitted to
Anything more to be included in the order for anybody?
No.
No. This will suffice? Yes. Service direction is there and the list to be
point be kept on.
Formally allow the
that is.
Sakshibe, add one line that this additional
Then
party
later on they will
can
see
1,
we
2,
did not
3,
add.
whatever are there.
It will be taken up for consideration. The numbers will be there in the order sheet. So all are being heard together.
Yes, that's my only reason is that this matter most likely it will travel. Most likely.
Certainly, not most likely. Oh,
Either way. Now,
it has been brought to the notice of the court that several writ petitions on similar issue is pending consideration. Stop. Let all the writ petitions be placed on board on 12th. Learned advocates are requested to supply the writ petition numbers to the officer attached to this court for enlistment.
Now the question of maintainability be kept.
The issue of maintainability, as raised by the respondents, is left open. Anything else? No.
Document from which petitioner I want to reply.
I have mentioned in the audit that all documents pleadings to be circulated. Please, everybody will circulate everything so that nobody is taken aback. Because this has got a long way to go.
This time we do not want anything happens where we don't participate.
Right.
We suffered a lot.
Yes.
That could be.
এটা এখান থেকে খুলে যাচ্ছে এটা এখানে